This is an interview with David Tannenhaus, James E. Rogers Professor of History and Law at the University of Nevada, Las Vegas. David, let's start with your telling us how you got involved in this subject, and particularly with the Chicago Historical Homicide Project.
In the early 1990s, when there was a real increase in youth violence, I became interested in when we first developed a separate justice system for juveniles. And one of the things that fascinated me that there was some literature about this court system and juvenile justice in general, but there weren't really studies that told you how the system worked. There was a lot of literature about what the sort of beliefs behind establishing a separate system were at the turn of the 20th century, but that you didn't really know what it was like to be in juvenile court, which children were there, what procedures and processes were used. And I was looking at a book that was published in 1920 by the U.S. Children's Bureau, a book by Helen Jeter, who had done some graduate work at the School of Social Service Administration at the University of Chicago. And in her book, which gave a pretty good view of where the court was about the time of the First World War, she mentioned that the case files for the juvenile court were public records kept in the clerk of the court's office. And I was fascinated by this because all the accounts I saw, nobody had ever used the records from the Cook County Juvenile Court. And so I called the clerk's office and found out that they had just established an archive. And the archivist said, well, I'll look into this. I don't know what we have, but I'll send somebody to our warehouse where we have old materials. And then this time he was an assistant archivist, although he's now the chief archivist. Phil Costello called me back very excited and said, I have great news and also some bad news. Great news is we found case files from this court dating back to July of 1899 when this court first opened. And he said, we're not sure which records were saved, how many there are, but this is great news. And then the bad news is that these are judicially impounded records, and you're going to need permission from the presiding judge of the court to look at these materials. As an historian, this was incredible news that I was going to have sources that I could potentially look at that people hadn't seen in maybe a century or so. And eventually I was able to get permission to look at these case files. And when I went down to the archive, I just had to sign a release form that I wouldn't use the names of the children and the families involved, but I could look at the materials and take limited notes on them. And the case files reminded me of the folders from the board game Life, that they were folded in envelopes, kind of a tri-fold, and each child, when he or she entered the juvenile court system, was given a permanent number. So if he or she returned, there would be additional paper in this folder, and the number remained the same over time. But the archivist couldn't figure out why these particular files were saved, that they seemed to be about 2% of the records from the period. So this was my first entry in trying to figure out how the court system worked. And then later on, when I learned from Steve Drizzen about your Chicago homicide database, it gave me a way to look at cases where the original files no longer existed of kids who had committed really serious and violent offense, homicide, and to figure out what happened to those cases. It was really difficult to figure out which cases were saved and why, that there were about the 2,700 cases, and a lot of them seemed to be saved in series, where you would have 100 cases in a row. And in the early cases, up until about 1906, there'd be a long description of the history of the case. You knew what the child had done. You saw investigations into the home life, the school, employment. And then after 1909 or so, cases were stamped with a purple stamp that says was and is delinquent. And you could see bureaucracy had kicked in, and you didn't really get a sense of what a particular child had done. So it was hard to figure out what happened with cases of serious and violent offenders. And one of the charges being made in the 1990s was that the juvenile court was ill-equipped to handle the cases of serious and violent offenders, that this system was designed to handle cases of kids who committed vandalism, were truants, hadn't really done very serious or adult-like crimes. And in the literature, the assumption was that kids who committed homicide must have been transferred to the criminal justice system and processed as adults. That we knew from records the court had kept that fewer than 1% of cases were transferred, but the assumption was, well, homicide cases had to be a part of that really small percentage that were transferred to the criminal justice system. And then when Steve Drizin called me up and said that the Chicago homicide database existed, that they had traced materials from the police ledgers from 1870 to 1930, yet every case of homicide recorded, he said, together we can finally answer this question of whether the world's first juvenile court handled or prosecuted cases of juvenile homicide. And we're really excited. So we spent time going through the materials and finding any case where there's identification in the police ledger that a juvenile was involved. We were interested in juveniles who were offenders or victims in these cases. We wanted to find the subset of juveniles. And once we came up with a list, we thought, okay, well, how do we find out what happened to these kids? And most of the juvenile court records were destroyed, that we could do some searches with names through the clerk of the Cook County Court Archives to find a couple of cases, but in many instances, those original files didn't exist, so we couldn't find out what happened.
Well,
Yes.
When you had the name of the juvenile victim or the name of the juvenile defendant, then what did you do?
Yeah. Once we had names, did a couple of things that looked that in any case that involved a suspicious death, there would the coroner's office would have an inquest, and they would bring people from the local community, witnesses, and they'd try to figure out what happened, what had led to the death of the person in question. And we found out that these records were available on.
That would be the same kind of coroner's inquest that they would have for an adult. Yes? No difference.
Yes.
Right?
Yeah, exactly the same procedure. And these records were available on microfilm. We went to the Illinois state archives to look at materials there. So I had a list of names of kids who were either victims or offenders that we could search through, and you could look that their materials are, well, they're fairly alphabetical, and in the late 19th century you get things broken down by a letter. So you have all the M's recorded. They might not be strictly alphabetical, but within that group you spend time looking through, finding a name that matches the name from the police ledger. Sometimes the spelling is a little off, but it involves detective work, which it's actually a pretty fascinating process. And once you find the microfilm, then you'll see that on one screen that you might have 4 of these different inquest reports. There's information about the coroner who's performing the inquest, the witnesses who were there, very often police officers, people from the community, and then there's usually a short description of what their determination was. And in cases involving kids, we found many, many cases where one child got access to a handgun and shot and killed another child. And these were often described as accidental homicide, but at the same time you could see the opinion of people in the community, which was that they were very concerned about the easy access the kids had to guns, that these things were going to happen. At the same time, there's also language that we saw where they said that that owing to the extreme youth of the offender, that they should be treated differently than an adult would be. So we saw kind of fascinating insights into the process. And then for some of the cases, we saw some simply the process ended with the coroner's inquest, that they said it was accidental, nothing needed to go on.
The purpose of the coroner's jury was to determine the cause of death, correct?
Yes, they're only supposed to list what the cause is. They're not supposed to say what should be done. To follow up. Yet it seems very often in these inquests they're making a policy recommendation of what should be done with this case, even though they don't have the authority to do that.
Were children testifying at those coroner's hearings?
Yes, we saw that in cases, particularly where one child killed another child. you might have 10 or 12 children as witnesses describing what what happened, whether it was a fight that went too far, or some sort of accidental death. So very often children seem to be the key witnesses involved. That this in the early 20th century, there's a lot of public life and culture. The kids are spending a lot of time
Outdoors.
outside. They often saw what happened, and in some of these cases, we realized some of them seemed very suspicious. That there was one case where it was described as death by baseball, that an older girl had thrown a baseball and hit a younger girl in the abdomen, and she uh, died as a result of internal injuries. Once we located names, found some material in the coroner's inquest, we had dates of when events happened. So the next thing to do was look at newspapers from the time. The Newberry Library in Chicago, where at the time I was at a postdoc research position, had wonderful materials, both census reports, so you could track and find where people lived in the city, and at the same time there were newspaper accounts. So with the Mary Raddick case, this death by baseball that seemed a little suspicious to us, we found out that this case was covered by the local papers. It wasn't front page news, but it was in page 3 or 4 of the papers, and the main account in the press talked about, initially we saw that there was discussion of this death by baseball, yet there was also a mention that in the local community, people were outraged that they saw um, the killer in this case, an older girl, had actually been terrorizing young girls in the community, and that they had gone to the police, they had tried to do things, and nothing seemed to be done. It very much seemed like a case that was ripped from the headlines of a paper today, something you would see on Law and Order. And so we were trying to figure out, so what happened to this girl who was described by some girls as beating this younger girl to death. And we found out that her case was heard by the juvenile court, and most likely she was sent to a women's reformatory until she reached the age of majority, which at that point is 17 or 18.
At what point is the decision made that the case is going to be a juvenile court case as opposed to an adult case?
The kids' cases were supposed to go to the juvenile court first, and then the juvenile court judge did have the discretion, if he saw that there's a child who he was particularly concerned about sending to an institution for juveniles, it might be a threat to other children in the system, he could dismiss the case and have charges then could be brought in, against the child in the criminal justice system. It would go to a grand jury, that their state's attorney would prosecute the case, trying to get the grand jury to issue a true bill, so that the case could then proceed to trial. The coroner's jury kind of had the first attempt to say whether the kid involved was somebody who had really done something where he or she should be prosecuted. The next stage, where grand juries were often uncomfortable with very young kids in front of them, saying that he or she is an adult, committed this offense, should be prosecuted in the adult system. The juvenile court system itself had a lot of discretion about what to do. And we saw at each of these points there were people involved who often said, well, this is a really young kid. Was he or she intending to do what he or she did? How culpable, how responsible they were? It seemed that there was a discussion going on at many points in the system, and we
So
contrasted.
so these institutional checks, the coroner's jury and the grand jury, they were really kind of acting as the conscience of the community. Is that fair to say?
Yeah, very much so. We saw that it very much is, groups of people forced to make this decision of how should the law treat a young person. And what we saw when we compared these cases to ones that were being handled in late 1990s, it seemed that there weren't as many people involved. And there was also an increasing role of prosecutors being able to make the decision about whether to file charges against a juvenile in juvenile court, or simply immediately charge the juvenile as an adult in the criminal system.
In the present period, you're saying, or at least in the late 90s,
Yeah.
late 1990s, the prosecutor by himself or herself could say, we're going to remove this case from the juvenile court.
Yeah.
Whereas there would have been in place in the historical period more institutional and community checks.
Yes, that seemed to be a fundamental difference to us, that the earlier system that had these institutional checks in place, we saw beginning to break down in the 1920s and 30s. There are a number of factors that led to this breakdown of the system. There was a concern that, and an argument made in the late 1920s, early 1930s, that, well, the juvenile court could have never been intended to handle the case of really serious and violent offenders. And we saw that argument seems to pop up every 20 years or so, kind of denying that the juvenile court ever had the competency. They hear these cases. So we saw a version of that happening in the end of our period that kind of foreshadowed what was happening in the 1990s. It seemed like we were repeating an earlier era in our history, and then there's a reaction to it where people say, well, we've lost a sense of that young people are different from adults. We've gone too far. Let's go back to the notion of a juvenile court. And one of the things that I think that we tend to do is we assume that the past had to be safer, less violent, that there's a notion that at some point we lost our way, and that today's society is the most dangerous society to live in. Yet when you go back and look at the late 19th and early 20th centuries, some studies that were done in New York, Eric Munkinen wrote a book about homicide, and what was fascinating was when he found out that young people in late 19th century New York committed homicide at a much higher rate than they did in the late 20th century. And a lot of these violent acts occurred in the workplace because you had very young people working under stressful conditions. Fights would break out. People would be stabbed in the workplace. And what was fascinating, as much as his work revealed this really violent world of young people, at the same time, when he described these cases, he also work from this assumption, well, it still can't be as bad as it is right now in the late 20th century. And we're really struck that, even a scholar working with materials from the past that suggested a really violent era still would draw upon the super predator myth, which was created in the mid 1990s to talk about this new breed of young, remorseless killers, that there are these young kids out there who, in the way they were described, didn't even seem to be human beings, who were just out to find people to harm and kill. A myth that was later discredited by the Surgeon General of the United States at the beginning of the 21st century.
Would you talk a little bit about how the juvenile court came to be founded in Chicago? What was it that was so special about Chicago that we had the first juvenile court?
There are a number of factors that lead to Chicago being at the forefront of this movement to establish a separate justice system for juveniles. The first thing I want to stress is there's an incredible group of women reformers based at Jane Addams' Hull House that played an instrumental role in both drafting and securing legislation. So, and these women were essentially the first generation of college-educated women in American history who were very educated, very skilled, and trying to find an outlet for their energies, their quest to secure social justice on a large scale. In addition to that, Chicago is the fastest growing city in the nation in the late 19th century. It's a city that feels overwhelmed by the growth that's going on. There's a sense that its judicial system is antiquated, it's out of date. There are concerns about whether it can handle adult cases effectively as well as the cases of children. At the same time, in the late 19th century, there's a real effort to say that the kids belong in schools, that there's effort also that they shouldn't be working in factories and mills, they shouldn't be wandering the city streets, that youth and childhood, these are categories that are being thought of in new ways in the late 19th century. And the women who lead the crusade in Chicago Lucy Flower, who had been an orphan herself, and then a very wealthy, prominent clubwoman in the city, really thought that it was a shame how young people were being treated. That there needed to be a better approach, and she joined with Julia Lathrop, who was really one of the first modern child welfare experts who was college educated. There are a lot of concerns about what's going to happen to the nation with so many people from other cultures and countries who may not understand the American republic. It's part of the reason why Jane Addams, sets up a settlement house in Chicago, is to try to have a conversation between people from different backgrounds, different social classes, to find some way to unify very different people to really enrich and expand American democracy. And one of the concerns that they have are these kids, for example, in the cities don't really have spaces or safe places to play, that the activities that kids engage in, if they're playing on the street and when somebody hits a ball and breaks a window, they've damaged somebody's property. If you don't have a separate justice system, you're going to take that kid, you're going to put he or she with adults, which is a really harrowing experience at this point, to have somebody even spend a night in jail and then appear before a judge who's probably going to dismiss his or her case. They're very much trying to establish a period in one's life where your responsibility is really to grow as a human being, to become educated, to prepare for the responsibilities of citizenship. And you can't do that if you're working, if you're not being educated. There's a real belief that the school system is absolutely essential, that if you don't provide these kids with a chance to become educated, literate, they're going to have very few options in this society. They may be forced either to turn to crime, they may end up destitute. So there's a real sense that kids need to have a somewhat sheltered existence. And one of the concerns in juvenile justice, both then and now, is that you don't want to take somebody who's going through this difficult period in his or her life and do anything that's going to so damage this young person that they have no possibility of becoming a good and productive citizen. And one of the things that the juvenile court is set up to do is it does provide a form of punishment and control through either putting people on probation and monitoring their behavior or sending young people to institutions, but it's supposed to be saying that it's not forever. It's to get somebody through this really difficult period in their life, and then they're going to settle down and form families and have some sort of work that's going to make a contribution to the larger society. And the concern then was not to either so stigmatize or damage a young person that they would be lost. And the concern was that it was the criminal justice system that took pretty innocent kids who hadn't done very serious offenses, put them with very hardened older criminals where they were likely to either be sexually exploited or educated in vice and crime, and you end up taking somebody who got into a little bit of trouble and ended up manufacturing a pretty violent and dangerous person. What's fascinating about the juvenile court is that there's this tension that on one hand, it's dealing with kids who have committed offenses, ranging from minor offenses to more serious ones, or at the same time, in the 19-teens, the court is expanding to play a critical role in the development of the American welfare state, that there are real concerns about what happens to single mothers, generally widows with small children, that there's a high rate of industrial accidents, death, desertion, and things. What's going to happen to children if there's not somebody to provide for their survival? And the juvenile court really does not want to take these children away from a mother who loves and cares for them and put the kids into an institution, which is both very expensive, it's also tearing apart a family. Juvenile court judges hate doing this, and they're able to secure legislation that provides, this is in 1911, there's a Funds to Parents Act passed by the state of Illinois that allows judges to pay pensions so that a mother has some funds so that she can pay the rent, she can put food on the table. She'll probably work a few hours, but not full time, and be there to be a mother to her children to make sure that they receive the love and guidance and rearing that they need. So the juvenile court has this very broad vision of trying to protect widows and children at the same time that they're dealing with these cases which involve providing assistance to the home, same time they're dealing with kids who have
Right.
committed very serious offenses. So it's a really difficult position that it plays the role of both a social welfare agency and also has the ability to really punish kids who commit offenses. So it becomes very complicated, and any institution you have that you're going to define its jurisdiction by the age of its clientele is going to deal with such a wide range of cases. And what was so useful for Steve Drizzen and I, when we worked with the Chicago Homicide database, is that we could fill in a piece, an important piece of this puzzle. We knew that the court, through the records that existed in the archives at the circuit court, dealt with a lot of dependent cases. We knew through records and reports from the time that they dealt with minor offenses. If a kid committed larceny or things like that, or girls were often charged with being engaged in sexual relations of one matter or another, were often treated very differently than boys. And now we could add this final piece of the puzzle of what happened to those kids who committed the most serious offense imaginable, those who committed homicide.
It sounds like actually the juvenile court itself changed importantly as an institution. It starts out as an institution which deals with juvenile offenders and victims, and then as the progressive movement develops and this welfare role becomes expanded and enlarged, it then becomes a kind of overarching sort of role over overseeing the family, not just the juvenile, and that's a really important development.
Yeah, well, it was really fascinating because when there were debates about mother's pension legislation in the early 19 teens, there's a real sense that you had to provide for widows with young children. And one of the questions was, well, how do you actually do that? How would you administer programs like this? And a lot of the people writing about this said, well, the juvenile court's already responsible for children. It's the natural place that if you had to think of an institution that was going to have programs addressed to young people and their families, the court seems like the right place. That people initially think, what a great idea. We'll expand the jurisdiction of the juvenile court to cover the beginnings of modern welfare programs and provisioning. Part of the work that I try to do as an historian is to show just the breadth of the juvenile court. So as scholars, we wanted to say that certainly the court handled these cases and did a pretty good job with it. But at the same time, we didn't want to lose a sense that the court dealt with such a wide range of other issues, and that most kids who go into juvenile court never end up actually, becoming adult criminals. It's actually been quite a successful institution, and it's one of the things I should stress as an historian. There's a real difficulty in whether we're either equipped or whether we should make any policy recommendations. What I found fascinating about working on this project, in working in collaboration with Steve Drizzen, who can play much more the role of an activist, is how we would blend the historian's perspective with commenting on contemporary developments in the 1990s. And I think it's one of the most challenging things to have done. And for me, it was eye-opening and made me realize how this historical research could help us think about contemporary issues without saying, these are the policies we must or should follow, but that the history can help us think about how difficult our choices are and maybe broaden our horizons a bit.
Let's say you found a case that you were in the Chicago homicide records. Let's say you came across a name and you of a victim or defendant, and you were like really wanted to know more about that case for some reason. It piqued your imagination, or you had a personal interest. What would you do?
What I found as a good first point, because these cases all involve homicide. There's going to be somebody who died, so you can go and look at the records, the coroner's inquest records, to find out a little bit about what people at the time, what their initial reaction to this case was when they were called together to make some sort of determination of what happened. And that also will give you the date when the person died, as well as when this hearing was. And then I would recommend going to a paper like the Chicago Daily News, and which covered a lot of crime and cases like this, and look, the couple of days after the initial crime happened. There are also translations of the foreign language press. Some of these are available if you're in Chicago at the University of Chicago Library. You can find out what ethnic communities thought in some of these cases. A lot of material there. You can also go, if you have a name, you can use census materials at the Newberry Library to find out where exactly in Chicago this family lived, that they're indexed by the last name. So if you know the family name, you can find out who's on that street, where there are a lot of wonderful histories of Chicago, particularly in the progressive era. They give you a sense of how the court system worked. I'd highly recommend. There's a wonderful book by Michael Wilrich called Socializing Justice, or the title is City of Courts, Socializing Justice in Progressive Era Chicago. Gives you a sense of some of the court systems. My own work about juvenile justice gives you a notion of the juvenile court. But newspapers are incredibly valuable source. And one of the things that surprised me in doing my research was I always assumed that juvenile courts from day one had private hearings. They were closed to the public and press. You wouldn't find any material or information. It wasn't the case initially. These hearings were open. The people who ran the juvenile court had to know how to deal with the press and publicity. And the early cases, you're going to have accounts that are going to give you the address of the kids involved, what the alleged offense is. And then later cases, really ones that generated a lot of controversy, might be on the front page. Leopold and Loeb, the case that captivated Chicago, the nation, and the world in the summer of 1924, right on the eve, the juvenile court. The founders were planning to throw an anniversary commemoration, bring to people who put the system together, bring them all to Chicago at the beginning of 1925 and talk about what the accomplishments were, what more work needed to be done. And then that summer, Richard Loeb and Nathan Leopold committed what was called the crime of the century, in which they murdered a 14-year-old, kidnapped and murdered a 14-year-old boy. And at the time were called the boy murderers, and led to a real question about whether we should have separate systems for young people. They were a little bit above the juvenile court age, but they were close enough and looked young enough that there were concerns about whether juvenile justice had been a good idea in the first place or not. Remarkable material about Leopold and Loeb. The other thing you can do is, if you find one of the cases, and I write about some of these, where somebody challenged whether a criminal court could prosecute a young person. Some of those cases made it all the way up to the Illinois Supreme Court. So there's some really interesting records there. And some of the other wonderful things to do is, you can, if you're interested in images, pictures, if you go to the Library of Congress, has an American Memory website that has the Chicago Daily News photographs, ones that were run in the paper as well as ones that were never run. You can do searches for images from pictures from this period, cases and names. So that's a wonderful resource to look at. Juvenile justice and this homicide project, they're incredible resources that people are just beginning to use. The work that Steve and I did, the article that we wrote, was a preliminary work. We clearly couldn't go through every case, but we wanted 3 that were similar to things that had happened, and then ask the question, well, how were they treated at the turn of the 20th century? How does a kid who does a similar thing, well, how's this case going to be handled at the end of the 20th century? But our work was very much trying to dispel this lingering myth about the juvenile court never hearing these cases. But ours was the first article on this issue, but there's a lot more work to be done. It's exciting area, and I would encourage people to look at the homicide database and try to put together and reconstruct some of these stories. We just started this process, but we, hope others will follow up and add to our understanding of these issues and this period. So it's an incredible resource, and I encourage people to use it.
Thank you.